afternoon, gentlemen. How are you?
Fantastic. How are you doing?
Doing well, thank you. We're joined this afternoon, barely afternoon, 2 minutes in, by Timothy Dance, who is the marketing director for Ganek PC. For those of you who don't know me, I'm Mark Seib. I'm a principal and managing attorney at Ganek. I manage our Midtown and Buckhead and Tucker offices. I've been with the firm since 1999, became a shareholder in 2015. I'm currently serving as the president of the firm and also the host of our monthly Ask the Attorney series. We began this a few months back, and hopefully we're providing some good information for members of our audience. We are recording, so we will also be circulating this, the recording via email as well, and posting it on our YouTube channel. So today's theme is we're doing a real estate pop quiz. So this was designed to have some audience participation, and we've got some multiple choice questions and maybe trip you guys up a little bit. And after we go through the question, I'll be providing some background as to why the answer is what it is. So Timothy, if you want to go ahead and pull up for us our first multiple choice question. So how many days does an ACH transfer take to clear and become available funds? So you have 4 choices, and we're going to let everybody have a moment to consider what they think the correct answer might be. All right, and I'm going to go ahead and submit my vote.
I may be wrong. I'm not in that department.
And then Timothy, if you will please reveal the correct answer. All right, so the correct answer is D, 15 plus days. So that's a little bit surprising maybe to everybody. So wires, I think everybody's familiar. Wires are immediately available funds in my firm's escrow account. So as soon as the wire is initiated and received by our bank, then those funds are immediately available. They cannot be pulled back. An ACH, on the other hand, can be reversed by the sender. And that's something that can happen for up to 15 business days after the money. So I can see the money has been deposited in our account, but it might not stay there. So ACH is fine for remitting earnest money as long as our closing date is more than 15 days out from the day of the closing. So if you are ordering title on our website, you have choices to do a couple different things. One, you can order title. You can submit your contract to us that way. Part of that process is you'll be able to select which of our 11 offices that you would like to close in. You can select from our 12 attorneys. So you can kind of make the dream team of attorney and location. It's your choice. Your buyer can also submit their earnest money to us. We're happy to act as the holder. And they can do that one of 2 ways. Well, actually 3 ways. So if the question was talking about is ACH. So we have a portal. We use a service called Forte, Forte, and it is an ACH online portal. So as long as your contract closing date is more than 15 days out, business days, then we're happy to receive the earnest money in that manner. We can also take, believe it or not, we can take a personal check, but the same rule applies. They have to submit the check and give us enough time to deposit the check and for the check to clear, where the deposit of the funds is final. It's all about the final deposit of funds. But for short turnaround times, then what we're going to do is we're going to open the file and we're going to send out an email with an invitation for your buyer to go to another portal called Certified, and that will give access to our wiring instructions in a secure format so that your buyer can know that they're getting the correct information. They're not getting a spoofed email that's coming from a third party. They can trust that they've got the correct wiring instructions. And when in doubt, they can always give us a call. Google ganekpc.com. You'll find our website. You'll find the phone number, make a phone call, and you can verbally confirm the wiring instructions that way for those who want that extra layer of security. All right, so Timothy, let's go to question number 2. All right, question number 2. Your buyer needs to bring additional funds to close of $5,002. How can the buyer pay? So we have 4 choices. You have to select one. So I'll let everybody take a moment to consider the different choices and make their selection.
I sure wish Angie Meza-Smith was here today.
All right, so Timothy, if you'll show everybody the correct answer, please. All right, so for question number 2, the correct answer is wire. So in Georgia, we have something called the Good Funds Law. For those of you who have been around for many years, like me, years ago, the number 1 lender in Atlanta was a company called Home Bank. Well, Home Bank closed a bunch of loans on a Friday, and they funded them with cashier's checks. And for those attorneys who went to the bank and deposited their cashier's check on Friday afternoon or Friday evening, they were fine. But for those who waited until Monday to go deposit their cashier's check, they were not fine because that cashier's check was not honored. So as a result of that debacle, where we had law firms who were actually ended up being the servicer of the loan because they had to fund the loan themselves with money out of their own personal pockets, we were able to lobby with the legislature and get the Good Funds Law passed. And the organization that really spearheaded that was GRECA, the Georgia Real Estate Closing Attorneys Association. And I'm proud to say that Ganek PC, we were one of the founding members of GRECA. So we got that law passed, and that's to protect not just closing attorneys, but the public. Because if you think about, for those closings where the seller walked out thinking, all right, my buyer just got their loan and they got funded and we're dispersing. And then on Monday, they didn't get the wire for their seller's proceeds because the funding actually never happened from the bank. So the public is benefited by the Good Funds Law as well. And the Good Funds Law basically says that any deposit being made to a closing attorney's account must be, that same term we just talked about with ACH, immediately available funds. And a cashier's check is not immediately available. So anything over $5,000 has to be a wire. We can take, at our firm, our policy is we will take a personal check up to $1,000. Between $1,000 and $5,000, it's a certified check is fine. And then anything above $5,000 has to be a wire. All right. So Timothy, on to question number 3. All right, number 3. What transfer technically triggers a security deeds due on sale clause? Owner to spouse, owner to child, owner to his or her trust, owner to sole member LLC. All right, we'll give everybody a second to pick their answer. All right, hopefully everybody's selected their answer. Timothy, let's see the correct answer. All right, so the correct answer is the one thing of these 4 that triggers the due on sale clause is an owner to sole member LLC transfer. So a lot of you may not know, what is the due on sale clause? So Fannie Mae, Freddie Mac pretty much every lender has in their security deed, the mortgage that the buyer signs at the closing table, something called a due on sale or transfer clause. And that basically says that upon any transfer of title to a third party, that triggers a default and the loan immediately becomes due. But there's certain exceptions to that rule. So if you think about in terms of estate planning, you as the buyer can transfer title 100% to your spouse, or you can transfer a 1/2 interest to your spouse. You can also transfer an interest to your child. Let's say you're an elderly person and you want to have a way to avoid your property going through probate. You could add your child to title and make them a joint tenant. And then upon your death, your child immediately becomes the sole owner of the property without having to worry about probating your will. You could also transfer title to your trust as long as the trust is for the owner's benefit or for the benefit of a spouse or for the benefit of a child. So it's the same people, it's just now we're doing it in trust form. But what you can't do without written permission from your lender is transfer title into an entity. And I tell you, we get asked this question at the closing table very frequently, and folks are often disappointed that the answer is no. And I'll say, well, yes, I can do that, but only if your lender puts it in writing. And that's the part that never seems to happen. And I can't take an email from a loan officer because they're not the underwriter, they're not the closing department, they're not the owner of the company. I need someone with the underwriting authority to give me that permission. So let me say another scenario. I've actually got this happening right now, where a boyfriend and girlfriend are buying a home together, and the boyfriend has not been in this country long enough to establish sufficient credit to be on the loan. So the girlfriend is getting the loan in her name, but some of the funds are coming from her boyfriend and actually from his parents. So I had a conversation with the loan officer on the front end. Hey, can we get this loan underwritten from the very get-go so that both of these people can be on title from the very beginning? Because if we waited until the end of the closing, I wouldn't be able to add the boyfriend to title because I'd have to have written permission from the lender to do that. And that wouldn't be something that has already been underwritten. So we'd have a problem at the table. So having that conversation at the beginning, the loan officer said, sure, that's totally possible. I'll put the boyfriend on the loan application as an additional title holder and we'll get the loan underwritten that way. So problem solved. But it's all about sort of thinking ahead. All right, question number 4. Question number 4, must a will be probated? So our answers are no, never. B, no, unless the estate has property. C, no, if the deceased wish in their will to avoid probate. Or D, yes, always. So let's let everybody submit their answers. This one's a little tough, I think. One of the harder questions. All right, so Timothy. So the correct answer is B, no, unless the estate has property. So if there's nothing to pass through the estate, then you don't necessarily have to probate the will. I mean, you can, but it may not be for any real benefit. Number C was just a complete, trying to mislead you guys. If the deceased, can't create a will and then say, I want to avoid probate, those things kind of don't really coexist. The whole point of a will is so that your wishes can be, carried out after your death. And the way you do that is the will gets submitted to the probate court, and then the probate court helps administer your estate. Your executor is the person who is appointed with the authority. Typically, if they're granted powers under the will, then typically they have the power to sell real estate. the will being acknowledged and accepted by the probate court as part of that process. So anyway, a little bit of a tricky question on that one. So, all right, let's move on to question number 5. This one's pretty easy, I think. So question number 5, who is responsible for past due association dues? So we've got A, agents under their fiduciary duties. B, owner at the time the dues were assessed. C, the current owner of the property. Or D, the association treasurer. So let's let everybody pick their answer. All right, so Timothy, if you'll reveal the correct answer. All right, so the current owner of the property. Yay, way to go, Todd. So obviously everybody probably laughed with the first choice. I mean, clearly agents are not responsible for the association dues. It's a little bit of a trick answer. The only way that might happen is where we have a scenario where the seller on an association is responsible for completing the community association disclosure, the CAD exhibit. And in my mind, it is the duty of the agent representing the seller to carefully walk your client through that exhibit and explain to them that if you leave something blank, you will be responsible for that expense if you don't disclose it. So an agent who failed to perform that duty and explain to the seller the importance of filling in the exhibit completely and accurately, then a seller might convince them that, well, you didn't give me good advice, so you should be responsible for what I'm now being asked to pay. So that was a bit of a trick answer. So that kind of could happen in a sense. Owner at the time the dues were assessed. Well, assessments aren't always due immediately. So they could be on like a payment plan. So then that's something that's typically negotiated by the parties. So a seller would have a duty to disclose that there are future special assessments that are coming down the road. And I sometimes see it where, a seller says, okay, I'm going to go ahead and pay that special assessment in full as part of the closing. Other times, different market, it's agreed, I'll pay the assessment that's due, or all of the assessments say that are due through the end of the year, but the ones that are due in year 2, 3, 4, and 5, the buyer is going to be responsible for those. That should also be displayed to us on the clearance letter that we get from the association. So when you're talking about dues, we can sometimes be talking about a lot of money. So it's very important that there be full disclosure and accurate disclosure also by the HOA and discussions ahead of time, so we don't have an issue come up at the closing table. So I see that a question just popped in. Anna asked, HOA responsibilities are like taxes, right? They're due, and whoever is the owner at drop dead time owes. So yes, that's essentially what I was saying. Other than one of those special assessments that is allowed to be paid on a payment plan and wouldn't necessarily be due at the time of the closing. But again, the buyer should be made aware of the future assessments that are coming, that are already voted on by the board, and should have the opportunity to negotiate to allow the seller to either pay or not pay. And sometimes they kind of split the difference. So that's really answer, Anna. That's really answer number C, which is, sorry, I just lost my, I closed out the wrong screen. The current owner of the property is the person responsible for that. All right, next question. And sorry, my final answer was the association treasurer. Obviously, the treasurer's duty is to collect the dues, not to pay them. All right, so back to question number 6. Is a survey required? And let's just say we're not talking about condos or or townhomes that have common walls. We're talking about single family. So yes, always. B, no, but always recommended for single family homes. C, no, but having one performed increases your title insurance coverage. D, only with the purchase of land alone. All right, if everybody wants to vote. All right, and then Timothy, if you'll reveal the correct answer for us. All right, so the question was letter A, yes, always. We would love to always get a survey because there's a lot of valuable information that's contained in a survey plat. And at Ganek, I can tell you, just like titles, surveys always get reviewed by an attorney. Just like titles always get, some firms, they let the staff members do that. At Ganek, the attorney is always involved. I mark up the survey, highlight things, write notes in blue, scan it, email it to the buyer's agent, let the buyer's agent ask questions, make sure that the buyer's agent is confident that they can discuss that with their buyer. And then we send it, and typically I let the buyer's agent forward it to the buyer. So they know that the buyer has it in hand and can offer to answer questions if needed. So the correct answer is actually B. No, a survey typically is not required by a lender. Now we're talking residential here. In commercial, lenders require survey coverage, and in order to get survey coverage on their title insurance policy, they need a survey or a recent survey that's certified as having no changes by the seller. But in residential, a buyer can get some survey coverage with what we call an enhanced owner's title insurance policy. But the downside of that is that the enhanced policy, some of the survey coverages have deductibles, and they also have caps on liability. So, if you have a sewer line running underneath your house, your cap on liability may not cover the expense of relocating that line. We, again, always recommend that a survey be performed so that the buyer knows what the issues are before they become the owner and they inherit those issues. Even if you're able to make a claim and get some of it paid by your title insurance company, you may be with some of that bill being your responsibility. So choice number C, no, but having one performed increases your title insurance coverage. That's not correct because, again, with an enhanced policy, you're getting some forms of survey coverage even without the benefit of a survey, but there is a downside to that. And only with the purchase of land alone, we're actually more concerned about surveying property that has improvements because we want to know the location of the improvements. Where's the house? Where's the pool? Where's the fence? Where's the stone wall? So the correct answer is B. All right. Question number 7. All right. Question number 7. Can you sell property in a pending divorce action? So A is yes, always. B, no, unless one spouse is entitled to the property. C, no, unless you have an agreement signed by both parties, which has also been entered by the court. Or D, no, never. All right, so what's the correct choice there, everybody? All right, so Timothy, if you can show the correct answer, at least I'm not seeing it on my screen.
It's not showing?
Well, I'm still showing quiz results. All right, well, I've got my cheat sheet right here, so I'll tell everybody the correct answer. The correct answer is C, no, unless you have an agreement signed by both parties, which has also been entered by the court. So in most or maybe all counties in the state of Georgia, as soon as the divorce action is filed, the court enters something called the standing order. And the standing order says that neither party neither the plaintiff nor the defendant may transfer title to any property, and that could be personal property, a car, stocks, bonds, their real estate, without the permission of the court. And typically the way you get there is the parties enter into a settlement agreement, and even the settlement agreement alone by itself, signed by both parties, is not enough really for the title insurance company to be comfortable, because the court still has to enter that agreement, accept the agreement, enter it. And so sometimes we're waiting for the not just for it to be entered, but to also show up in the records as having been, officially accepted by the clerk of the court. So what we do in some of those scenarios, if we have an agreement between, let's say it's husband and wife, both on title, they're both agreeing to sell the property, they've come up with an agreement where they agree how to split their proceeds, but we don't have acceptance by the court yet. What we will often do is either hold the proceeds in escrow, or we will, with the agreement of attorneys for both the plaintiff and the respondent, we will transfer all of the proceeds to one of the two divorce attorneys so that they can hold the funds until the parties' agreement has been accepted by the court. We've actually gotten permission from a title insurance company, even when they're still haggling over, but they agree to the terms of the sale. So they agree to the sales price, that they'll pay, let's say, $5,000 in closing costs. As long as we have them both agreeing, we'll have them each attend closing, initial each page of the settlement statement, and sign on the signature page. And then again, all the funds will go to typically into one of the divorce attorney's hands to hold until such time as they finalize their settlement. All right, so let's try number 8, see if the functionality here in Zoom is going to work for us for the next one. All right, question number 8. If your seller is an estate and the deceased owner had a will, what does your seller need to provide to the closing attorney? A, will, B, letters testamentary, C, taxpayer identification number, or D, all of the above. All right, so I was able to submit my answer that time, Timothy. Let's see if our correct answer will show up this go round. All right, we're back online. So the correct answer is D, all of the above. Now, I will say the seller doesn't necessarily have to provide this information to us because we will ultimately get this information, well, A and B, we will get that as part of our title report. But I see this very commonly. We get contracts that are signed by the executor of the estate, and they just sign their name, and they don't include their title, and they don't say the estate of the dead person. So when we open our file, we think that the executor is the owner of the property. And then we go look at the tax records and we discover, oh, well, there's a different name. Wonder who that person is. If they have the same last name, we can usually figure it out. Well, this probably is an estate, and that's probably the person who signed is probably the son or daughter of the person who passed away, or the spouse of the person who passed away. But it sure would be nice if we could be told on the front end when we first receive the contract that we're going to be dealing with an estate on the seller side of the transaction, because that will mean that we will open our file the correct way, we will order title from our examiner the correct way, and our examiner will know that they also need to go to the probate court and check those records too, because normally the search is just the real property records and the civil filings, but they're not going to go over to the probate court and search those records unless we tell them to. So a lot of times title reports come back and they show title vested in the dead person, and then we'll go back into the person who signed our contract and say, well, who's this? And they, oh, that's my dad. He passed away a year ago. oh, well, you have a different last name. So let us send our examiner back to the courthouse to search title a second time. And then they go back and we find out, well, the probate isn't located in, let's say it's DeKalb County. Well, that's because Daddy lived in his house in DeKalb, but by the time he passed away, he had already been moved into a nursing home, and the nursing home was in Gwinnett. So Gwinnett ends up becoming the county where the will gets probated, even though the property is in DeKalb. So now we have to send our examiner to a different courthouse to go to the probate. So if we have the will and the letters testamentary up front as part of the contract, all of those questions have been answered. So we tell our examiner when we first place the order, we need you to search the real property records in DeKalb, and we need you to search the probate records in Gwinnett, and then put all that together into a single report. Now the letter C, taxpayer identification number, many executors or administrators of estates will give us the social security number of the person who died. Well, once you're dead, you can no longer earn income. You can no longer file a tax return. That becomes something that the estate does. So the estate should have a separate taxpayer identification number. And if you're being well advised as an executor, you're told apply for a TIN or an EIN, a taxpayer or employer, or there's several names for those, but essentially not a social. But TIN is what we normally are telling people they need. So that's going to be often required for you to open an account for the estate, because your job as the executor is to marshal all of the assets of the estate, make sure that you have enough liquid assets to pay all the creditors of the estate. So if you have to sell property in order to have enough cash to pay the creditors, that's your job. And then after that, if there's stuff left over that you can pass according to, like, let's say the will left the real property to a specific person. And if the estate had no debts, then you can transfer title into that person, which was what the deceased person wished. But if you don't have enough assets, then you're selling the real property in order to liquidate the funds that are, the profit from the sale, so that you can pay the creditors. And we make the executor sign an affidavit at closing that all the creditors of the estate either have been paid or will be paid as part of the sale of the property. So the correct answer again is all of the above. All right, question number 9. If your client is an LLC, what documents must your client provide to the closing attorney? So choice A, certificate of good standing, articles of organization, and operating agreement if one has been adopted. B, bylaws. C, corporate seal. D, letters of administration. All right, we'll give everybody a second to answer that one. All right, so Timothy, if you will reveal the correct answer. All right, the correct answer is A. So an LLC, to form itself, files articles of organization. To contrast, if you're a corporation, you file articles of incorporation. Both of those are filed with the Secretary of State. They become a public record. We can, when we get a contract, we can, go online. We do. The closing coordinator, that's part of their job of getting ready for closing, is we check to make sure the LLC still exists, that it hasn't been dissolved or administratively dissolved. We will go ahead and print out the articles of organization, save those to our electronic file folder, and then we will ask the seller, do you have an operating agreement? Or if this is a commercial transaction and we have an LLC as the buyer and they're getting financing, then they're going to be borrowing money. And we need to make ensure in both cases that the LLC either selling or borrowing money has the authority to do so, and which person can come to the closing table and sign our documents. And if there is an operating agreement, our answers will be found there. If there is no operating agreement, we need to know that, because now we're going to look, is the answer in the articles of organization? And the sad part is Georgia does not require the answer to the question of authority to be in the articles of organization. So I don't even know necessarily online filing, one-page document. You can create an LLC, but not disclose who the members are and not provide the name of any manager. So that's why we're usually looking for an operating agreement to help us answer those questions. Now, choice B, bylaws. I guess I've seen some LLCs that adopt bylaws, but that is very unusual. Bylaws typically go with corporations, and the bylaws would tell us who has the authority to sign. We're also going to ask a corporation to give us a resolution, a corporate resolution to sell real property or to borrow money from a lender. For a corporation, we're also going to be looking for a corporate seal, because corporations, they can sell property one of two ways. Either two officers sign at closing, usually it's the president signing and the secretary attesting to the president's signature, or we have one officer plus a corporate seal. So one of the questions, if we're dealing with a corporation, is does the corporation have a corporate seal? And if the answer is no, then we let the parties know we're going to need two officers to come to closing. And then choice D, letters of administration, we're going back to the previous question, which is that has to deal with probate. All right, let's close that one out and we'll move on to question number 10. All right, number 10, if your seller is an LLC, their proceeds can be wired to the owner's personal bank account. True or false? We get this one a lot too. All right, so Timothy, the correct answer is false. So we get asked this a lot. And the title insurance companies really frown on this, and I'll explain why. So let's say the LLC was formed and our articles of organization were kind enough to tell us that there is a single member forming the LLC. And let's say that happened back in 2015. So here it is, 2023, 8 years later, and we're being told by our seller, the person who signed the contract, the original single member, that I'm the one owner. I've never adopted an operating agreement, and so as the sole member, I'm also the person who has the management authority for the company. Well, that sounds great, but what if in actuality, in 2018, they sold 50% of the membership interest in that company to another person? So now we have actually two members, but that's not showing up in the public records. You could file an amendment to your articles of organization to say that the organization, the LLC, now has two members. And if I were that member buying in, that's what I would do. But with two members, I'd also probably want to have an operating agreement so that if me and my business partner have some sort of dispute, we have a way of solving our dispute. If, let's say, the membership interest, let's say I bought 60%. Well, now I'm the majority. So I want to make sure that as the majority holder, I have the right to do certain things because I'm the majority owner. So, there may be new documents that came into being after that LLC was formed. So if we were to sell the property, let that original sole member sign our docs, wire all the money into their personal account, and then they wire the money to their account in Aruba and promptly jump on a plane, guess what? That 60% owner of the LLC who bought in 2018, he or she is not going to be too happy with us. And when he or she discovers that the property has been sold, they're going to sue everybody involved. The buyer, the buyer's agent, the seller, the seller's agent, the law firm that did the closing, the title insurance company. So that's the reason behind that policy. It's a lot. It can be frustrating for folks because they don't always maintain an account in the name of their LLC. In those scenarios, we again end up holding their funds until they go create an LLC account, and then we so once we wire the money out, we can't control what happens after that. In those scenarios, I would require the seller, the person who purports to still be the sole member, to sign essentially an affidavit saying that they're the sole member. I get them sworn to and subscribed under oath. So swearing out a false affidavit, you can sue on that. So we add some extra, security for the parties and for the title insurance company underwriter, but it's still not a perfect solution. And that's just, unfortunately, something that Georgia's current corporate law allows, which we regret, but we do with it as best we can. All right, number 11. And Timothy, if you could also just quickly check the chat function for us and make sure we don't have any other questions in there. So question 11, who should not act as an attorney in fact for the buyer seller? Who should not act? A parent, a child, the real estate agent, or a neighbor? Who should not act as the attorney in fact? So we're talking about power of attorney. The person who acts for the grantor of the power of attorney is called the attorney in fact. Who should not act as the attorney in fact? All right. All right, so no other questions in the chat box. Thank you, Timothy. So let's go ahead and reveal the correct answer. All right, the correct answer is the agent. So every broker that I know of has a policy that they do not allow their agents to act as the attorney in fact for their buyer or their seller. So we're always looking for a friend, a neighbor, a parent, a child, a sibling, someone that has some sort of relationship to the party that they're going to be signing on behalf of. For buyer powers of attorney, that's typically one spouse is at closing. They're signing for themselves and their spouse who can't attend. I actually had one a day or two ago where it was one sister signing for her other sister who had traveled back to their home country for several months. So question from Duncan, is that a rule of law or does it just keep things clean and limit liability for agents and brokerages? It's the latter. It is legally allowed, but I will say that title insurance companies also frown on that because the agent has a financial incentive to get the deal closed because they're going to earn a commission. So title insurance companies don't like it. We don't like it. Under maybe some rare circumstance, but we're going to have to really sort of delve into that and make sure that the title insurance company would allow us to make an exception to the normal rule. So good question, Duncan. All right, let's close that one out and move on to question 12. All right, all of these are acceptable methods of a buyer executing loan documents except for, so be careful with this one. So all of these methods are acceptable except for, so it's acceptable to execute documents in our office, out of our office with an attorney supervising via audiovisual technology, virtually with a remote notary signing electronically, buyer's attorney in fact in our office. So which is the one that we cannot do? All right, so correct answer, C, virtually with a remote notary signing electronically. So some states have adopted a remote online notary bill. In fact, it's starting to become the majority of states, but a lot of them haven't implemented their rules. A lot of times that solution isn't yet available because of either a title insurance company won't allow it or a lender won't allow it. So there's many parties to a transaction, especially if it's financed. So obviously, loan documents can be signed in our office. That's the most common way. They can be signed out of our office with an attorney supervising via audiovisual technology. Now, I will say that there is a Supreme Court opinion in Georgia that says we can't do that. But when we were in the pandemic, we had an emergency order from the governor's office, which temporarily allowed us to do this. And so what some of us have been doing going forward is, if we have the ability to have a notary physically in the same place where the person is signing, out-of-state notary by themselves, they're not an attorney. An attorney is supposed to be supervising the execution of any document that provides for a conveyance of real property. So by using the audiovisual technology, we can supervise, because we can see it, we can hear it, we can ask questions, we can explain documents, but actually we do still need a new advisory opinion from the Supreme Court to allow us to do that. Now, the clear incorrect answer is C. Virtually with remote notary signing electronically, Georgia does not yet have a remote online notary bill. There is, presumably, we're going to have one introduced in the legislative session, which is going right now. Whether it will pass this year remains to be seen. We've had bills introduced for the previous 2 sessions. So over the course of 3 years, we have had bills introduced but not passed. And then our final choice is buyer's attorney, in fact, in our office. Yeah, routinely done. Like I said, just did one of those 2 days ago. All right, so next question. We've got 12 minutes left. So let's see if we can get through the rest of them. 13. All right, question 13. Can a buyer or seller ever sign closing documents internationally? Choices are A, never, B, yes, only if it is with a notary appointed by the foreign country, C, sometimes with a foreign country, but can always sign with the U.S. Embassy, D, never with a foreign notary, only with a U.S. Embassy. All right, this one's pretty tough, I think. All right, everybody got their answers submitted? Okay, Timothy, if you'll reveal the correct answer. So the correct answer is C, sometimes with a foreign notary, but can always sign with the U.S. Embassy. So there is something from The Hague, The Hague, it's called a convention. Essentially, it's the same thing as a treaty. And various countries have signed off on that convention. I think it's convention number 12, which recognizes notaries and apostilles, another term, from another country. So if we get, I have this happen, sellers who own property here and then their job relocated them to another country. When we get an email or a phone call from the listing agent, how is my seller going to sign? Does my seller have to come back? What are we going to do? We'll say, well, we could do a mail away. We could also have your seller sign a power of attorney. Where, in what country are they located? So we'll be told which country it is. We'll go the Georgia Superior Court Clerks Cooperative website. So y'all are probably all familiar with that, the GSCCCA.org. That's where you can go and look up real estate documents online. Well, they also publish all of the members of that Hague Convention. So we can look quickly and say, okay, that country has signed that convention, so we can allow your client to go to a notary, because sometimes people are located somewhere where the U.S. Embassy isn't nearby, or the U.S. Embassy has a waiting period that's several weeks, or the cost is going to be a significant amount of money. So there's various reasons why some folks might want to not go to the U.S. Embassy. So we're going to work with them and allow them to use a foreign notary whenever possible. But D, that's what we often have to do is, if that country is not a member of the Hague Convention, then if they want to sign remotely, they're going to have to go to the U.S. Embassy. And the sooner we know, the sooner they can make an appointment, the sooner they can get their doc signed, the sooner they can get them back into, usually it's from overseas, it comes back to us via DHL. We will always provide a FedEx air bill to return it back to us if they have access to FedEx, but sometimes they need to go to DHL instead. So, all right, number 14, 8 minutes left. Question 14, a trustee must provide the entire copy of a trust agreement to purchase or sell property. True or false? All right, with just 2 choices, hopefully everybody's got their answers in. Timothy? The correct answer is false. So it depends on your trustee and how much they are willing to trust us with their trust documents. So we can also rely on something called a certificate of trust, which is sort of a summary of what's in the trust agreement without giving us the entire trust agreement. Those typically come from the attorney who prepared the trust agreement. They are witnessed, sometimes witnessed, always notarized, signed either by the attorney who prepared the trust or by the trustors or the trustees. We'll wait to see what the certificate of trust looks like. If it's not got enough sort of bells and whistles that make us feel comfortable, we'll typically just send a copy over to one of our title insurance company underwriters and let them give us an answer. Some folks may not realize that a certificate of trust is acceptable. So if we have pushback from the seller or from a buyer who's getting financing, let me say on the financing side, if they want to take title from the get-go as trustees and sign their loan documents in that capacity, I guarantee the lender is going to want to see a full copy of that trust agreement. But we can sometimes make do with the certificate of trust as long as the certificate has enough information contained within it so that we can prove the authority and that we can rely on it, that we know that it's like sworn to under oath. Then it can be an acceptable substitute. All right, question number 15. All right, number 15, if your buyer or seller is a corporation with no corporate seal, which representatives need to attend closing? I may have already given y'all the answer to this one, but so choice A, president and manager, B, vice president and member, C, 2 corporate officers, D, president or secretary. And I know I talked about this, so you should be able to get this one. All right, let's reveal the correct answer, Timothy. 2 corporate officers. All right, so the answer D is a little tricky because if they did have a corporate seal, then we could have either the president or the secretary attend, as long as we have a corporate resolution that says the president will attend the closing and sell the property at 123 Main Street for a sales price of $100,000. Or it could say the secretary will attend. As long as that officer shows up with a corporate seal, we're good, because we have to have 2 things. 1 officer plus a corporate seal, or 2 officers. So 1 to sign, 1 to attest. All right, so that's the end of our quiz. Timothy, let's see if we have any questions in the chat function. I don't think we do, but one last chance. Anna, you want to ask another question?
No, thanks.
All right. Well, thanks everybody for attending.
Crashing the party.
Say again?
I feel like I'm crashing the party a little bit. I'm a buyer, an investor who's closed several properties with Ganek. So,
oh well, thank you for joining us.
Yeah, I like to be informed.
All right. Well, thank you again. Thanks everybody. Hope you have a great rest of your day.